Pete Serrano with the Silent Majority Foundation is here. He is my lawyer, and he is the one, along with a couple other free speech warriors with the Silent Majority Foundation, who filed my lawsuit against Washington State. If you're new to the podcast, first off, my real last name is Westover. Surprise! My full name is Allison Morrow Westover. I went by Allison Morrow, which has been my middle name since I was born. On television, I was Allison Morrow, publicly Allison Morrow. For privacy reasons, also just easier because my maiden name was Abrahamson. So I was Allison Morrow Abrahamson. It was just a tongue tie. So I changed it to Allison Morrow. I just kept it short. And then I got married to Lynn Westover. I became Allison Morrow Westover. Anyway, you all know me as Allison Morrow, but my real last name is Westover. So if you're confused, who is Allison Westover? That is the same person you're looking at right now. Okay, Allison Westover versus the state of Washington. What happened here? I used to be a TV reporter, right? Pete and I was working for Washington State Department of Natural Resources after I quit TV. And COVID happened. I was interviewing people on my personal podcast. And my bosses at DNR told me that I needed to stop, even though they knew about the podcast and everything, but they did not like the content because they had a vaccine mandate. And they told me that my guests were undermining their vaccine mandate. And I had to quit. I said, look, this is on my personal time with my personal gear. You can't tell me, you're the government, what I can do, who I can associate with on my personal time. They said, yes, we can. And so they fired me. So we have filed this lawsuit, and now we have finally heard back from the state. Pete's here to tell us about what's going on. So, Pete, they are going to file a motion to dismiss, and they have filed their response. Where do you want to start with all this?
Let's kind of take it chronologically. So a few weeks ago, they filed what's called their answer, which responds to all the allegations made in the complaint. This is typical. Some people will file a motion to dismiss in lieu of an answer. So when we saw that they answered, we were wondering kind of when the motion to dismiss, or if they'd seek another similar type of motion called a motion for summary judgment, if that was forthcoming. But I will tell you, in the answer, it's very kind of Melba toast, if you will. It's standard operating procedure: deny, 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 admit things that are really benign to the case. But there are a couple of, I think, nuggets that give us a sense of where they were going and what they were thinking when they wrote the answer, that maybe we can tease out in this discussion.
Yeah.
And then yesterday, go ahead.
Pete, real fast, let me just tell people that if you want to read all of these documents, you can go to the Silent Majority Foundation website. It's also where you can donate to support the hard work of Pete and the other attorneys. They have lots of free speech cases, Second Amendment cases. They focus on constitutional liberties. So if you want to learn more about them, or you want to support their work, go to silentmajorityfoundation.org. If you go to silentmajorityfoundation.org/WestoverVDNR, that's my page. So you'll see that. And then, you can see complaint, defendant, response. So I'll click on that. So here we are. And yeah, let's start with, the beginning. Like you said, I don't know much legalese, but it seemed very boilerplate in a lot of ways. Like, one of the things they say a lot in here is, we don't have the knowledge, so we're just going to deny it. I thought that was funny. We don't know.
I thought that was, in some places that felt, maybe either out of place or just kind of like, really?
Yeah.
That would have been asking your client like 3 questions.
Yep.
But I also understand, these guys and gals are working several different cases. And quite frankly, it probably doesn't hurt them too much to not have, sufficient knowledge about something. Because again, as I mentioned, when we've litigated against the state and against this outside counsel, the outside firm, Pacific Law Group, that they've hired, kind of the SOP, the standard operating procedure, is either file a motion to dismiss and then answer if it's not granted. Mm-hmm. And then sometimes what happened in your case is they filed the answer, and we found out yesterday in a conference call that they intend to file a motion to dismiss sometime the next week or two. And that's also typical if you really think that you've got, the ballistics or, the support to get through a motion to dismiss. I don't think it's there, but I obviously have to see what they're going to say before I can really make an educated decision on how we're going to move forward to oppose that motion. Mm-hmm. But this answer, again, it's got like, this asserts a legal conclusion and, stands for itself, or we deny it or we accept it. But it is interesting, in my opinion, when you get to the back end, they've got what are called affirmative defenses, which if those stand, basically those are dispositive in and of themselves. In other words,
That
if you got
mean dispositive.
it means that it's a win, right? If your affirmative defenses stand, you have fully defended against a claim. Obviously, judges don't look at an answer, which is what you have before our audience, and say, "Oh, there are great affirmative defenses. The case is over." You still have to litigate it through a motion to dismiss or a similar motion called a motion for summary judgment, which allows a judge to say, "Hey, there's really no issue here. You all agree on the facts, and the law really is in the plaintiff or the defendant's favor." And so these affirmative defenses, if they were proven true through a motion to dismiss or a motion for summary judgment, would really this is like the foundation that they're laying to get the case dismissed.
Give
But
me an
again,
example. Can you give me an example of something, an affirmative defense? What are you calling it again?
An affirmative defense that then has to be supported through what's called a dispositive motion.
Oh,
And that's
dispositive.
a motion to dismiss or a motion for summary judgment. And think of the root of the word dispositive is dispose. So it's a motion that disposes of the case. Because I always liken it to wrestling or MMA or whatever the case is. It's a tap out motion. It's the type of motion that if a judge finds in a party's favor, terminates the case automatically. Obviously, appellate rights occur. In some instances, they'll grant these motions, but they'll also say, well, come back with a better complaint. We will grant you the opportunity to amend your complaint and you can address it. And so, again, in looking at what is generally the answer is generally kind of a straightforward run-of-the-mill answer. I do think it's interesting when you come to the back end, page 15, when they assert these affirmative defenses, they bring in particular, the fifth one, something that I thought, we intentionally didn't really address your COVID-19 exemption, right? From the shot, from the vaccine.
Okay. Yeah,
right. And
I
so when you
see.
look
Yeah,
at five,
that's this one, right? Basically, we would have fired her anyway because she didn't get the COVID-19 shot.
and they obviously don't come out and directly say that, but there's no other COVID-19 directive.
Right.
And so it's interesting to me that they bring that into the litigation because, again, what we did with the case was stand on First Amendment free speech, freedom of press issues, and then a workplace that imposed conditions that didn't really exist, and wrongful termination under those First Amendment protections of both your free speech and your right to press and right to associate. But we didn't delve into the commissioner's mandate. So I thought it was so interesting that they brought this in. I don't know if that's a tip of the hand as to where they intend to go with their motion to dismiss.
Pete,
go ahead.
Well, one thing I'm just curious about is, and this was in one of the emails that I sent, my final email, which we included in the exhibits for the lawsuit, was my saying, hey, if you're firing me over the vaccine mandate, you haven't followed protocol according to the state's requirement to give me my meetings over my exemption and or what was it originally that you got? You accommodation. Okay,
you
right.
Got you got the exemption and then sought the accommodation through
and
the process.
they didn't. Yeah, we never went through the process of the accommodation. They were supposed to take people like me who had filed for an exemption and received the exemption. The next step was supposed to be, okay, you meet with HR and we go through your work duties and decide, can you do your job without the COVID-19 vaccine? But I never had those meetings. So I don't know how much that's going to matter. But when they say, hey, we would have fired her anyway, it's like, well, wait a second. How do you know that? You never gave me my meetings to decide whether or not I was going to have to be fired. So, I mean, that seems unethical. I don't know. I mean, what do I know? I'm not an attorney. I'm just somebody who has a wine club. And hang on, Pete, let me just tell people about, hey,
yeah.
you're look, there's going to be plenty of opportunity to have a great glass of wine while reading some very boring legal documents as we go through this process. Okay. Or maybe they're very exciting legal documents. I don't know. You know, those memes where it's like Michael Jackson in Thriller and he's like eating popcorn that people send. That's going
Yep.
to, you got to have a good glass of wine to swallow all that down. Okay. AllisonWinePromo.com. You get 6 bottles every 3 months, and you can send them to Pete every time, you know, we have a win in the case. You can send him and the Silent Majority Foundation a bottle of wine, keep them, send them to grandma, whoever you want to send them to. And if you're a wine drinker, you keep them. It's a win-win. They're all hand selected for the kind of products that I really like, which is extremely limited, small batch production, families that have been working on wines for, in some cases, hundreds of years, grapes that are grown between 6,000 and 9,000 feet, very remote parts of the world, natural fermentation, no added dyes, flavorings, any of that kind of stuff that's in commercial grocery store wine. So they're just very high quality, and it's a great way to support the show. AllisonWinePromo.com. Okay, so yeah, let's go back to that question. If they try to argue, look, it's a moot point. She doesn't have standing or whatever they say in legal terms because she was going to get fired anyway. So what are you even talking about here? What do you think about that response of mine where I say, well, wait a second, how do you know I was going to be fired? You guys didn't follow the protocol. I mean, how does that affect their argument?
Well, and I think that's where the court's going to kind of just brush over it, quite frankly. I mean, it's not one that can really take on water, if you will, in the sense that that's not an issue before the court right now, because to your point, we could have, had that been the issue of the case, raised all the issues that were necessary to prove out that they failed to follow their protocol on the termination based on the mandate. But again, in this case, we knew darn well that that wasn't the case. This was all about you and your ability to produce a product and utilize your YouTube channel. And the notion that you spoke against, you know, the commissioner's mandate, I think, quite frankly, just shows largely intent to, you know, scorch your speech. And so it's interesting that they brought this in. It just, when I read that, I was just like, you know, you're trying on the wrong shoe, you know, and it just, that's really what it felt like. But, you know, I get it. You know, a lot of folks will throw the kitchen sink in, even if, you know, the spoons are in there and the spoon doesn't need to be used. Right. And so this certainly feels like a kitchen sink approach. But it's so interesting. And what I hope is that the judge doesn't kind of take on to it, and I don't foresee it. Certainly would be an issue that we would either raise on appeal or, you know, challenge any decision that brings this into play, because again, that's not an issue in the case right now.
Mm-hmm, mm-hmm. Okay, AllisonMorrow.locals.com is where you can put in questions ahead of time for interviews or comments for people like Pete. And you can also send me mail, P.O. Box 3355, Denellen, Florida, 34432. Love getting the notes of encouragement. I'm sure I'll need them in the days to come. So send me notes, Bible verses, seeds for the garden if you'd like, though I do have quite a few seeds because somebody just sent me a massive box. The producers, my kids, open the mail. They love going to the post office and getting the mail. So just nothing creepy. And don't bake cookies or something like that, because I'll assume you put anthrax in them and you're trying to kill me. Okay, P.O. Box 3355, Denellen, Florida, 34432. And then going back to locals, Zoji says, stay strong. Thank you for fighting these a-holes. I still have quite a few followers from Washington, so I think there are some people that, because I used to be a TV reporter in Seattle. We live in Florida now, but we lived out in the Pacific Northwest for 10 years. So there are a lot of Washington folks who are kind of like, oh, what happened to Allison? You know, she was this TV reporter, and now she's this internet rebel, outcast, naughty corner on YouTube, suspended multiple times. Zoji, did you name your naughty goat after this Pete? Because now we have a farm and we have a buck named Peter. No, it just, the stars aligned. We have Peter the goat and Pete the attorney. All right. There was another question, okay, about Trump is reinstating military that were terminated and barred from continued benefits with back pay. Can this be used for precedent? Is a question. I don't know if that has anything to do with my case, though. Probably not, because those were related to the shot.
Yeah, and so that's kind of level one. Is one, again, the whole first 15 minutes of the conversation have been on this notion that it's odd that they'd bring the shot mandate into it when that's not what you were terminated for. So no, it won't help. I mean, certainly, does it maybe if we get to the point where we're in a jury trial, does it maybe open the gates to a jury having a different viewpoint? Certainly, I think it's helpful in that sense. But also, even if it were related, if this was a vaccine termination case, there'd still be the issue that that was done through executive order, and he is undoing a different executive order. And so, that would be a federal versus a state thing. And until Washington state wakes up to the damage they've done to its people, which I don't know if that will happen in my lifetime, but hopefully it will. Nonetheless, until Washington state wakes up and kind of reverses its course, that really would be where the rubber would hit the road in a vaccine termination case based on state law.
Okay, when it comes to the motion to dismiss, that will come, I'm assuming, in a few weeks, and then the next step is a judge decides whether they are right to have that, and then it's just thrown out, or we file a response to their motion to dismiss, and then the judge decides on both of those.
So when it comes to these motions to dismiss, there's a motion, a reply, or an opposition, or a response or opposition, and then a reply. So they get cut 1, we get cut 2, they get cut 3. So they open with, here's our position of why it should be dismissed. We say, no, it shouldn't. And then they get to respond to our no, it shouldn't, not adding new elements, right? And so it would be solely, we'd respond to them and then they'd respond to us. And so that's the process. It's usually about a 6-week briefing schedule. Sometimes we'll agree to extend it out depending on whether or not, we've had these same attorneys in different cases throughout the state. And at one point they asked to enlarge in their pages and extra time to write it. And we said, okay, but give us the same courtesy of the same amount of time and space to respond. So, we try to keep some sort of working relationship in case we do need to ever file for an extension. But yeah, I would anticipate that if they file something in the next week, 2 weeks, within the next 6 to 8 weeks, it'll be fully briefed. And then the judge would have, hopefully, either we'd have a hearing or we'd decide it just on the motion itself, or, and then at that point, the judge would have time to decide and have a ruling post either hearing or post date that's marked as, quote, the hearing, but the judge decides just on the papers. And that would basically round out about 3 months.
Okay. All right. If you would prefer reading some stuff on Substack, if you're on Substack, this is where this case, I'll be, I can share links and stuff. That and locals, that's another option. If you prefer to do Substack over locals, I just wanted to let everybody know I am on Substack, AllisonMorrow.substack.com. I just published an article about the food freedom workaround of these farmers that I've been interviewing who are doing private membership organizations instead of doing government permits. And so it's just interesting. It gives me another option to publish written material. So go over to Substack and check it out. That'll also be available on locals. So if you're on locals, don't worry about it. If you would like to support my personal costs, like travel back and forth to Washington, babysitters, time I have to take off the podcast in order to do stuff with the lawsuit, then you can go to givesendgo.com/Allison Free Speech Fight. Again, Pete and his team have taken the case on contingency. So if you want to support them, givesendgo.com/Allison Free Speech Fight for me. If you want to support them, it's silentmajorityfoundation.org. Okay, silentmajorityfoundation.org. And that's also where you can go find my case at silentmajorityfoundation.org/Westover VDNR.